Hi, this is Advocate Lucinda, your empowerment lawyer. Today I want to talk about sanctions. Sanctions that are issued from the court against the party. I'll say, I want to give you some tips on things to look out for to avoid being sanctioned and how to respond in the event you are sanctioned. I have spoken with some of you who have said that you have been sanctioned. So let's get into some things that you can do because I want you to be encouraged. I don't want you to file a frivolous lawsuit. File a lawsuit that has merit, that has a basis in fact for bringing the lawsuit, because I want you to get justice. So let's look at plausibility and the standard, because plausibility is key to surviving sanctions. The case Twombly at 550 US 544, it sets forth the standard. It states a complaint must be plausible on its face and it must bring forth sufficient factual allegations that nudge a claim across the line from conceivable to plausible. In other words, you want to make sure that the facts and the law are on your side. The allegations in your complaint should sound real. The allegations should sound believable. The allegations in the complaint should cause the judge to say something like this: this case needs to move forward. Discovery needs to be had to determine if plaintiff's allegations in fact are true. So rather than dismissing this case on defendant's motion to dismiss, we're going to deny that motion and give plaintiff an opportunity to make out their case further. Again, it's critical that before going into the lawsuit, pro se, make sure that the facts and law are on your side, because the judge writes the plaintiff's narrative. Plaintiff, the judge writes your story as told by you, beginning with your complaint. Now think about this, and it will follow you throughout the entire litigation. So what happens if the judge's narration of your story is wrong? Think about that. Depending on the materiality of the narration's error, it could harm your case. Let's say, for example, that the defendant filed a motion to dismiss. Depending on the materiality of the judge's narration, it could harm your case. For example, let's say the defendant filed a motion to dismiss, and in the district court's order responding to defendant's motion to dismiss, the judge wrote that plaintiff answered yes to a particular issue. However, plaintiff answered no. Or let's say the district court judge left out a material fact that the plaintiff included in their complaint altogether. So plaintiff appeals the case, and the appellate court judge reviewing the district court's narrative could construe the plaintiff as having answered yes rather than no. And also, the appellate court judge would not have access to that information that the district court judge left out. You want to perfect the record for appeal. You want to ensure that the correct narrative is in the record. You want to amend your complaint or file a motion for leave to amend your complaint. Remember, the court must be liberal in allowing an amendment as long as the claim is plausible and not futile. You are perfecting the record for appeal. I want to say this to pro se. Typically, judges are not inviting when it comes to you filing a lawsuit in the first place. That's just a fact. You will pay a price of some kind, as many of you know and who have said that to me, who have shared that with me. And I know that what you've said has credence because in my 28 years of practicing law, I've seen it. And I've had to deal with it myself. So you will pay a price. That's why I encourage you. Be sure that you know your facts and that you have covered the law that supports your situation, putting it all together. Don't let bad attitudes get to you. Keep your eyes on why you filed your lawsuit. The ultimate goal is to get justice. Don't give up. So let's talk about sanctions and the standard of sanctions. There are two that courts use quite a bit. Rule 11 sanctions and then 1927 sanctions. Federal Rule of Civil Procedure 11 provides that a district court may sanction attorneys or parties who submit pleadings for an improper purpose or that contain frivolous arguments or arguments that have no evidentiary support. Federal Rules of Civil Procedure 11. Regarding sanctions for 28 U.S.C. 1927 sanctions, it states any attorney or other person admitted to conduct cases in any court of the United States or any territory thereof, who so multiplies the proceedings in any case unreasonably and vexatiously may be required by the court to satisfy personally the excess costs, expenses, and attorney's fees reasonably incurred because of such conduct. You know, a year ago, I uploaded a video entitled Write Your Complaint with the 12B motions in mind. And that's still true. I want to add litigate with the Rule 11 and 1927 sanction statutes in mind. So you see the importance of the narrative being correct and perfected for a potential appeal. Pro se, going into a lawsuit with these attitudes do not mean that you do not believe in your case. Given that judges make errors, you want to be equipped to defend yourself in your case. You have that right. Next thing I want to talk about is the findings of facts and conclusions of law. What are they? And when a judge is required to make them. Federal Rules Civil Procedure 52, in general, in an action tried on the facts without a jury or with an advisory jury, the court must find the facts specially and state its conclusions of law separately. The findings and conclusions may be stated on the record after the close of the evidence or may appear in an opinion or a memorandum of decision filed by the court. Because if you are suing, you need to know this statute, Federal Rules Civil Procedure 52. In regards to sanctions, generally, findings of fact and conclusions of law should be included in an order granting or denying sanctions in order to allow appellate review. I will leave you a link to an article, interesting article, that gives examples and case law that address when a judge should make findings of fact and conclusions of law. You will find a discussion concerning the case cited below. Scholler versus Davis. And some courts permit litigants to request that the court make findings of fact and conclusions of the law. Check out your local rules regarding that. Absent a statute stating otherwise, ask the court to make the findings of fact and conclusions of the law. If for no other reasons, here are two: to perfect the narrative of the case and to perfect the record for appeal. Hey guys, I hope this has been helpful to you. Thank you for watching, and we will see you next time on Advocate Lucinda, your empowerment lawyer. Take care and Merry Christmas.